Yes, my lord. Whilst we are waiting for the witness, I would like to introduce a new exhibit that the witness will also make reference to. It is marked as Exhibit 0001. The witness will refer to such an exhibit.
Oh, one.
Yes. And we will provide the original copy of the document to the defense.
Okay.
It's a single page, my lord.
Single page.
Yes.
There's another document here, 000.
Yes.
So this one joins.
Indeed, my lord.
Okay, fine. So West End Kim.
Saying they gave us an original. I've got a photocopy here.
We will provide the defense with the original.
I want to say it before this witness starts to testify, because we do not want to validate the evidence of this witness before we see the original. May we kindly be provided with the original before he starts to testify.
Where's the original, sir?
My lord, it will be provided to the defense.
Does it exist?
It does, my lord.
Where is it?
It was made from the original.
Where is it?
Send its way, my lord.
Actually, we have indicated to the state earlier on when we were given these copies that we want to verify with the original register.
Maybe, my lord, may I add, the court is always concerned about the fact that the JP is also concerned about the manner in which this trial is dragging on and on and on and on and on. I can only sincerely hope and believe that the court is taking note of the fact of what is happening here, because this is going to constitute yet another delay. I can only sincerely believe that those delays do not always come from the side of the defense. This is caused by the state, because they come here in the morning, they throw us, they give us this information, they do not even speak to us about the original, they come up with new information on a daily basis, and they expect us to be up and above and start to proceed with the matter on the basis of this new information that they give us on a daily basis. I'm very concerned as well.
Is this about the record of the traveling?
Indeed, my lord.
Of
On
the
the
vehicle.
27th of October 2014, we're only referring to a single entry in that document.
Which is what?
Doesn't matter.
The third entry, my lord.
17922.
That's correct, my lord.
Okay, it will be provisionally admitted because they say it's coming. If it doesn't come, then the admission will be expunged. Okay. Yeah, can you start then? Yeah, Ibu?
I have not consulted because I thought that we were going to be provided with the original.
Yeah, they say this document only pertains to the third entry, ne?
Correct, my lord.
Nothing else.
Nothing else.
Yeah, you can consult Mr. Umal.
But my cross-examination, my lord, is not going to be limited to that entry.
Yeah, but the state says they're not going to be utilizing the other information on this document. Are you not saying that, sir?
That's what I'm saying, my lord.
Yeah, you can consult. If you want to consult.
It's dangerous, my lord, to be handed with a document, a leaflet such as this one without the entire register, because we don't know what is happening here. So we want to compare and contrast the sequence of the information that is contained in this document from the original source. And if we don't have the
So you want,
original source,
wait.
able.
So you want the register, it's the complete register.
That's the original document.
Do you want the complete register?
We don't know whether it comes from a register or what, but that's the original source where this information is coming from.
What is the original source, Mr. Sibanda?
It's a logbook, my lord.
Where's that logbook?
Well, if I can suggest that we can start with the opinion, Exhibit 000, then we get to Exhibit 001 later.
It shall have suddenly come about.
And then during lunch, my lord, we can see if we cannot arrange for the
What's the time now?
original logbook. 12:17.
Is that okay? They say they can start with the original document.
It's not okay, my lord. It's not okay, and that is not the procedure for the witness to start when the parties know that the witness will be testifying on both exhibits.
Yeah, but they say the document in question will be available after lunch. Okay.
My lord, it should be unfair to start with the examination.
You know, you guys, you're just picking up trivialities. And I quoted a case to you. Director of Public Prosecutions versus the Eastern Cape. Where's that case? Just let's quote it again, please.
But my lord, the state-
No, wait. Let's quote that case because they say people, wait, Mr. Mnisi. They say, the law says, we mustn't put imaginary obstacles. Just quote that case again. It's not me saying that, it's the law.
But my lord, these are not
And it's an
imaginary-
SCA case. I can't overrule it. Let's see that case.
My lord, with due respect, the state knew when they made copies of these that the defense is going to request original copy. Why did they not bring it in the morning?
Have you got that case?
Trying to find the relevant passage.
It was written by Harams, man. Is it Harams? Director of Public Prosecutions. Eastern Cape. The other day, we just drew that case. What's the problem now?
My lord, I will read from paragraph 13 if it's the correct passage. In any democratic...
No, just quote the case itself, so that it shouldn't be said, I'm creating new law. What's the citation of that case?
Attorney General Cape Good Hope Provincial Division and another. Key versus the Attorney General Cape of Good Hope.
Nah, that's not the case. That one is by, I told it's by Harams. You're reading me a case by Kirchla now.
Yes.
Hey, my daughter. Jesus. That case talks about the fairness or otherwise of Section 35 pertaining to the litigants before a court.
It's National Director of Public Prosecutions and King.
That's the one. Wait. Yeah, that's the one. Is it by 5 judges? Harams. Just count the judges so that. Hello. Harams.
Nugget Mlambo.
Nugget
Malan,
Mlambo.
and Mijit EJA.
And who
5,
else
yes.
also?
And Malan.
Yeah, Malan. 5 judges. What are they saying? Not Ratha, the law. What's the problem now?
We are trying to identify the relevant paragraph.
I think it's the 3rd paragraph also. I can quote that case for you. It's fairness in a case, it's a two-way street. Have you got that paragraph?
Paragraph 5.
What does it say?
There is no such a thing as perfect justice. A
Yes.
system where an accused person should be shown every scintilla of information that might be useful to his defense and discovering criminal cases must always be compromised. Fairness is not a one-way street conferring an unlimited right to an accused to demand the most favorable possible treatment, but also requires fairness to the public as represented by the state. This does not mean that the accused's rights should be subordinated to the public's interest in the protection and suppression of crime. However, the purpose of the fair trial provision is not to make it's not to make it impracticable to conduct a prosecution. The fair trial right does not mean predilection for technical necessities and ingenious legal stratagems, or to encourage preliminary litigation. Let me just go down.
Yeah, okay. What in simple man's language, what do they say? These 5 judges.
My lord, what they are saying at this stage is to say exactly demonstrate what is happening now, that now the defense is only picking this one entry from which is going to delay the court to further proceed at this stage just for a very minor issue, which is one entry, and they submit that the delay that is being caused, it will result in an unfair trial to the accused person, not considering the fact that also the public being represented by the state, it should also be taken into consideration.
Yeah, and this court is making an order to say if that piece of evidence is not brought to court as undertaken by the state, it will be expunged. I don't know what a judge should do. And here are 5 judges saying you can't go for predilections and try and stop a trial on a minor issue. I mean, it's a minor issue of a car which is supposed to have been used on the 2014, on the 27th, sorry, on the 27th of October 2014 at 10:15. It is alleged that this VW Jetta, which belongs to support services for the Division of Forensic Services in October, it was used from the forensic laboratory, I think, to Force Laura's crime scene examination under case number 63/10/1, and also used to the residence in Centurion. And it is signed by Captain Mangena. Okay, you can continue.
Lana-ke udaba belumayelana nokuthi ke le document umbuso oyivezayo-ke ufakazi azokuthi ufakazi kayo abameli-ke bathi cha babefisa ukuthi bangabona-ke originally-ke kwasekufundwa-ke manje-ke lo mthetho othi-ke akungabhekwa-ke into ey'ncane ezingathi-ke zilungiseke-ke ekuhambeni kwesikhathi ngokuthi-ke kulibaziseke ukuqulwa kwalo icala. Umehluleli uthi manje-ke uthatha isinqumo sokuthi-ke ungaqhutshekwa-ke manje uma kuwukuthi le document ayizi-ke nanjengoba umbuso uthembisile, ila khona-ke manje inkantolo isizoshintsha-ke isinqumo sayo ukuthi-ke manje lokho kushiwo mayelana nalokho ayafika idocument leyo, lobo bufakazi sebuzokhishela ecaleni, kodwa kwamanje bangaqhubeka-ke.
Sorry, why don't you read that word which says scintilla of evidence? You know what a scintilla of evidence? You haven't read that thing completely. They're talking about an instance like this, a scintilla of evidence. They mean feathery light evidence, which is innocuous. Just read that also.
There is no such a thing as perfect justice.
Yes.
A system where an accused person should be shown every scintilla of information that might be useful to his defense.
That's it. Wait, yeah, that's it. It's enough. They say, these judges, 5 judges are saying that, not me. When there's an undertaking that scintilla of evidence will be brought, this court can make a ruling on the basis of those 5 judges.